Welcome to Clienting, the place to get information about legal marketing and client development in the digital age. Here are your hosts, Tskalakis and Kelly Street.
Hello, everyone. Just wanted to let you know that for today's episode, my audio quality is not awesome. So apologies to your ears for that, but hopefully you can make it through and enjoy the awesome interview that we had with Will Hornsby.
Kelly.
Hey,
What's going on?
just doing my thing, sitting here with a microphone in front of my face like everybody else in the world.
Are you excited?
What am I not excited?
Are you super excited?
I am super excited. I was lucky enough to meet the gentleman we are speaking with today this past summer, but I think everybody else in the legal world has known him for much longer than I have.
Yes, I've had the good fortune to know Will Hornsby for many years now. He is no doubt a superstar in the legal community, and we are very grateful to you, Will, for taking the time to join us today.
Oh, thank you. That's a very generous introduction.
Not at all. If only we had video, we could do something more even extravagant in your introduction. But since we're limited to our voices, we'll have to settle for that. But why don't you tell listeners a little bit about yourself, what they should know, and what you're up to these days?
Sure, thanks. I worked for the American Bar Association for almost 30 years as staff counsel in the Division for Legal Services. I staffed a number of small entities that were fundamentally dedicated to providing services to people of moderate income who have a little too much for legal aid or pro bono representation, but not enough for traditional representation. And so the group that I worked with had revolving members, and those members brought issues to the table that we advanced, including things like court-based self-help centers, unbundled legal services, technology-based efficiencies in practice, just kind of a hodgepodge variety of innovations, many of which have unfolded over the years. I also staffed early in my work at the ABA, I staffed something called the Commission on Advertising, and that was a 7-member commission that was focused on addressing issues having to do with lawyer advertising and its regulation. And we weighed in quite a lot on the regulation of lawyer advertising and the ethics rules that pertain to that. And so what that did was give me kind of a 50-state, 51 jurisdiction overview of what those rules are and how they're different from one entity to another. So when I left the ABA at the end of last March, I kept doing what I've been doing, and that is trying to advance access to affordable legal services, just in a different platform, a totally different platform. I went from a 900 staff organization of over 400,000 lawyers to being a true solo practitioner. And I practice under the law office of Will Hornsby. And I have a very artesian practice where I focus on helping people understand the intersection of ethics and opportunity. And the foundation of that is the concept that the more you understand about the ethics rules, the more you can advance innovative models consistent with those rules, and also collaterally understand where the boundaries are and what becomes very difficult to do.
Well, congratulations on hanging your shingle.
Thank you.
That's exciting. And needless to say, this is an area that's extremely important for the future of lawyers as technology and the practice continue to evolve. And it is an area that a lot of lawyers struggle with. I think, you're on the cutting edge, and I think it's easy for all of us in the technology and forefront marketing areas to get somewhat trapped in a bubble. But a lot of lawyers are struggling even with the basic idea of delivery of services in a way that's different from what they've done for the last 2,000 years. And so I'm really curious to get some of your thoughts on that. And where are we right now on that stuff? Do you talk to a lot of lawyers that are thinking in that direction, or is there we're trying to nudge you to be thinking about innovation?
I think it's a matter of nudging and demonstrating opportunity. The ethics rules definitely have a chilling effect on people going outside of the box with some frequency. We at the ABA, when I was at the ABA, some of the last projects I worked on identified, for example, the extent of unbundled legal services, how lawyers could provide a limited scope representation. And one of the things that we found that it's a mile wide and an inch deep. We found that about a third of the practitioners indicated that they provided unbundled services, but they also only did it for 20% or less of their practice. And that slice of those who did it in a more consistent basis was a very narrow, single-digit percentage of lawyers who approached that kind of innovation. And so it seems to me that that's a tremendous opportunity for practitioners. It seems that it's a tech-based opportunity that enables them to license document preparation services, for example, but it's a hard sell. And lawyers are reluctant to adapt and to make those changes.
Right. And it's such an interesting thing too. And it's funny too, now that you're not with the ABA, and I won't be presumptuous that you feel more comfortable sharing your opinions, but you were always very careful throughout the years of making sure that, you always presented a very fair and balanced view of the committees, the various rules. And one of the things that I run into, and I'm always someone like you, just fascinated because of your experience to be able to get your opinion on this kind of stuff. But I was recently at an organization of lawyers, this dynamic between the protectionism within the practice, even from lawyers, certainly from committees. Are you seeing that change, or is that still a big obstacle in terms of trying to get some of these innovations pushed forward?
Yeah, we're seeing pockets of change, but it doesn't seem to be broad-based. And so what we find is that different states have different personalities, if you will, about this, some of which are very restrictive and proprietary, and others of which are much more open to experimentation. So, for example, New Jersey and to a little lesser extent, New York are pretty fundamental, whereas California, right coast, left coast, has a lot of dynamics going and has a dedication to access. And I should back up and say that the state bars in particular and the Supreme Courts, state's highest courts, they do have a dedication to improving access, but they frequently don't make the relationship between the restrictions that exist within the ethics rules and the opportunities that exist to expand access. And I think that we're siloed in that sense, and it would be great if the ethicists and professional responsibility folks had a better conversation with the access to justice folks, and we could explore that. And there are people in the organized bar that are interested in furthering that conversation. It needs to be a really collaborative effort. We can't rely on the ethics community as such to make those changes. We can't rely on the access to community to understand what changes need to be made in the rules. And so that ecosystem needs to be enlarged, and we need to have outreach. So I think it is happening. We have access heroes in places you might not imagine. Texas Chief Justice Heck, a Republican, has been extraordinarily supportive of efforts to increase access to justice, but still the Texas Supreme Court has not amended its rules in ways that better accommodate that. So there are folks that are interested and dedicated, but it's not coordinated to an extent, and it's not collaborative to the extent necessary to really effectuate those changes. I think that California, which has a new task force on access to justice and has some really talented people involved with that, might show the way for that. And the ABA has done work in that area, and that's reflected in the changes to the model rules that govern attorney advertising. Some people, including myself, don't think that those changes went far enough. But what we're seeing, and what's really exciting about the advertising rules, is that they're going in the right direction.
More movement than we've seen in a long time, right?
Yeah. A new ABA opinion was issued just the other day that had to do with the ethical aspects of lawyers financing clients' fees, and was very access-oriented and very permissive. On the other hand, earlier this month, we had the Virginia Ethics Opinion 1885, which read in part like it was authored in 1885, that basically listed comprehensively all the aspects that were problematic with the AVO model of fixed fee, unbundled services. And so, it was well reasoned, well written, and created a lot of obstacles. So we have these different dynamics and states going in different directions. But fundamentally, if you look at this as a movement, that movement goes toward more liberalization. There's probably some lines in the sand here that will not be crossed in my lifetime to any significant extent, and that I think has to do with non-lawyer ownership of law firms.
That's what I was going to guess.
Yeah, that's the big hurdle.
When you're talking about new rules that are coming down or changes that will happen quickly, I think it's kind of ironic that the marketing and advertising ethics rules are typically kind of outdated and don't include digital marketing or new forms that we have now. But ironically, those forms like Twitter are where the kind of legal trendsetters are talking and making a lot of noise and figuring these things out together and trying to figure out how to attack the problem. And so I think that's one really big area that needs to be kind of explored a little bit more probably by the ABA and other organizations to say, okay, what is this noise? What is the conversation that's happening on social media? And how can we start to change a little bit more quickly, probably? Yeah,
there's no question that the changes in the governance of lawyering and advertising is a major part of that, moves very slowly, where technology literally moves at the speed of light. And you make a really good point about the ability for us to govern technology. And there was a time when this started out that you could, what I would do is always say, what is it like? Okay, so I'd see a website. So what's the governance of a website? Well, what is that like? That's like the Yellow Pages. So the rules, that would govern the Yellow Pages could accommodate governing the internet. Email solicitations, what are they like? They're like snail mail solicitations. So the rules that govern snail mail solicitations accommodated that. I'll share with you a story about how I became recognized as an expert in this area. And this goes back to the mid-1990s when there were just a handful of lawyer websites. And the internet was becoming ubiquitous. AOL was, becoming a major player. People were using email in a big way. And I made a presentation. I made quite a lot of presentations in those years to the Legal Marketing Association, which are marketers fundamentally from large and mid-sized firms. It used to actually be called NELF, the National Association of Legal Marketing something, and now it's LMA. And they had they still do. They have chapters. And I was making a presentation to the Chicago chapter, and it was a luncheon presentation, and people were kind of crammed into this room, and there was a lot of noise and chatter going on near the kitchen, and it was hard to hear. And I, walked through this, and I had this very fundamental, I might not have even had a PowerPoint at that point, but I went through my typical spiel about how the rules apply to what they do, and they need to be concerned, blah, blah, blah. And toward the end, someone asked me, so do these rules apply to our use of technology, to the World Wide Web, as it was known then, right? And I had never given that a moment's thought. And what I did was I paused, I took a drink of water, I'm thinking, right? And I'm thinking to myself, well, why wouldn't they? There's nothing in the rules that say that the rules that apply to television or radio or newspaper, the rules are the rules, right? And so I did like 90 seconds about how, of course, the rules apply, with great confidence. I used to get the print version of the Chicago Law Bulletin, the legal newspaper. And I opened it up, and there was a front page story right in the middle of the front page that said, rules apply to the use of technology, expert. And I swear to God, I said to myself, great, here's somebody I can call up and find out about this. And of course, the story was about me.
Oh, that's so great.
the National Law Journal picked up on that, invited me to write an article about it. I did a little, phone to people I knew and trusted in this area, and kind of came up with some theories about how the rules apply. And in fact, that's what everybody ultimately embraced. But the rules are an imperfect fit. And so they become a challenge for us to progress. And as the technology has gone exponentially forward, and the rules have stayed fundamentally the same, it aggravates it all the more, because we're at a point where we can no longer say, what's it like? What's Facebook like? What's it like when we have technology that can draw from our group of Facebook followers? What's it like? What's anticipatory delivery, right? Amazon wants to do anticipatory delivery. So they know if you bought the last 20 Van Morrison albums, you're going to buy the next one. So they just send it to you, right? So imagine that for legal services. Imagine that you have in your house one of those pods with Siri or Alexa, and they become something that reaches out to you because they gather the data that they get from hearing everything you do. So imagine that Siri says, Kelly, I heard the bill collector calling you again. Would you like me to refer you to a nearby bankruptcy lawyer? That technology exists, right? And the only reason why we don't have that right now is because Google and Amazon haven't decided to do it. But how do we regulate that? What rules apply to that? How is that false or misleading? How is that something that we govern? How do the lawyers who participate in that get direction on whether or not that participation is something that's ethically permissible for them? So that's our challenge. That's part of the challenge of moving ahead. We have to go beyond this concept of what it is like and try to figure out how do we craft rules that are responsive to the capabilities.
Similarly, I've seen the location-based Facebook ads where personal injury lawyers are advertising based around hospitals.
Sure.
And sending out their ads to people who are scrolling through Facebook while they're sitting in their hospital room after a car accident. And is that ethical? It technically fits within the guidelines as far as I know, but is it really great?
Yes, it is.
Yeah. It is great. Yeah. That's sometimes the gulf between ethical permissibility and a sense of professionalism. And there are certainly people who would argue that that's just professionally inappropriate. And there are other people that would say it's an opportunity that can't be avoided.
Yeah, absolutely. And it can definitely fall in either category, just depending on how you feel.
No legislating for taste.
Yeah.
At least there shouldn't be, but
Exactly.
different subject. So one of the things, kind of as we dovetail into getting into some of the specifics, one of the things that we run into all the time, and I'm sure a lot of listeners struggle with, is the fear of violating a rule. And, we don't position ourselves as ethics experts. We remind our clients every lawyer is responsible for their own ethical marketing. We try to, the best we can, make recommendations based on the rules that are applicable. But, as a lot of the rules can be pretty vague sometimes, especially when you get into some of these more difficult areas. So what kind of guidance can you give lawyers, especially that are, frozen by, the thing that I'm always sympathetic to them is, there are some lawyers that are, they're out there pushing the envelope and throwing caution to the wind. Are there certain bright line types of things that you can tell lawyers to say, hey, you know what, alleviate some of this fear if you do X, Y, and Z? Or is it really so case by case nuance that if you're afraid, you just can't play the game?
Yeah, I think lawyers have an opportunity and an obligation to know what those rules are that apply to them. Now, from the participating lawyer's perspective, that's frequently not a difficult thing because they have a limited number of states, if perhaps one, perhaps just a couple, in which they're delivering their services. From the service provider's perspective, that becomes much more complicated because obviously the technology scales to be universally available and ubiquitous. So I think that it's always a good idea to make sure that participating lawyers understand that they do have an obligation. But it's like I said, I think it's really important that they understand that they appreciate that an understanding of the rules creates opportunity for them. It shouldn't be viewed as something that creates the roadblock. It should be viewed as something that challenges them to determine whether or not they can do any particular, participate in any particular platform that it creates greater opportunity for them. So you'll find lawyers who will rush to whatever models there are. You'll find lawyers who will never go there. You find lawyers who don't want to go there. They just, they like it the way it is, and they're not going to be innovative unless and until they have to. But I think that my whole predicate, my practice is based on people, lawyers, embracing the concept that knowledge about the rules is something that facilitates better opportunity rather than closing those doors. Now, there are things that they're just not going to be able to do that they might want to do. But knowing that, I think is a method of protecting them from the risks that emerge from various models as well.
I love that perspective.
One thing that I'm curious about is calling back to the access to justice. One thing with that, we talked about this a little bit with Patrick Pallas, but didn't dive too deep into it, is, thinking about access to justice and the marketing and solicitation ethics. How do you reach out to the population that may not even know they have a legal issue if you have all of these restrictions around soliciting clients?
There's no question that there's a challenge there, but I think there's a lot of different opportunities. It's hard for me to convey this verbally, but I created a grid where on the horizontal axis, if you just visualize this, the horizontal axis, you have people who don't know they have a problem and people who know they have a problem. So that's that continuum. On the vertical axis, you have people who know their problem has a legal solution and people who don't know that it has a legal solution. So you create a quadrant. So much of our effort is pushed up into that upper right-hand quadrant where people know they have a problem and know there's a legal solution to that. So those are people that are served with summons or subpoena or process. Those are people who are being evicted, in the process of being evicted, foreclosed on, debt collection. Their spouses have filed for divorce or some domestic relations issue. Those are people who have been in traffic accidents and know they have personal injury. So that's a huge part of our response to legal need, but it ignores that other three parts, those other three quadrants. And I'll hesitate to say that they are equal in stature, but medical legal partnerships, for example, would be that area where people know they have a problem, but they don't know it has a legal solution. So a quick example of that, a family with a child with asthma, and they go to the doctor, and the doctor questions them about their living environment and determines that there might be mold, which is the root cause, or at least an aggravation of the asthma. And the doctor knows that he or she can treat the child, but that it won't be completely successful as long as there's mold in the apartment. And so they'll partner with a lawyer who will have a conversation with the landlord saying, let's get rid of this mold conversation in some form or another. And so that's the solution. That's the legal solution to the problem that the child has asthma. And so there's lots of different ways that we can deal with that quadrant. My favorite quadrant are people who don't know that they have a problem and don't know that there's a legal solution to that problem. And I'll give you an example of that. This would be people in assisted living who are widowers or widows and have a romantic relationship in the second season of life. And they need prenuptial agreements, but they have no idea they need prenuptial agreements. And so maybe their children will figure that out. Maybe they won't. But that's a preventive measure to protect assets. And so it allows them to enjoy their time together, but not necessarily the assets that they built up over a lifetime of work. And so that's an example of a legal service that needs for people to understand that there is a problem and that there is a legal solution to it. And so I have a lot of fun kind of playing around with that grid, and it's something that I think helps understand the complete dimension of the need for access to justice. It's not just those people who know that they have a legal problem.
Man, if you could fill in that one quadrant with all, well, maybe not all, but a ton of the people who don't know they have a problem and don't know that it's a legal issue, you could provide so many content ideas for so many different practice areas to be like, oh, well, you know what? We need to start writing pieces on this so that, someone's grandson who is searching, my grandma's getting married, is there anything she needs to do or something like that? They can know, oh, this lawyer has an article about it. They need a prenup.
Yeah. Another probably far more common example are real estate taxes and appeals for real estate taxes. Because how do you know if you're paying too much? I mean, now you can go on Zillow. People who are astute to this know they can go on Zillow and see what their neighbors are paying. And if it's out of line with what they're paying, they know they have a good case for a tax appeal. But people generally just don't know that they're paying 20% more than their neighbors with a comparable house because just the history of the transaction of the property turned out that way. And it's nothing they did or didn't do to cause that circumstance. And they just don't know that it exists.
Particularly relevant example for us in Illinois.
Yeah, absolutely. But they're going to fix that, right?
That's what I hear. So let's do some kind of basic marketing ethics blocking and tackling, because I know you really exist at the intersection of some of the examples you already gave are like really sophisticated problems. Some of the, just to put some things out there, and again, without getting too mired down in some of the nuance, what kind of advice do you have for folks about things like online reviews? Is that something where you just say, hey, stay away from it? Do you suggest that people encourage happy clients to go online and leave reviews, or do you kind of stay out of that kind of area of recommendations these days?
Yeah, no, I'd be happy to talk about it. Let's talk first about the happy clients. I think a lawyer who has a personal legal practice, a personal services legal practice, would be foolish not to encourage his or her good clients to write reviews. I think reviews are testimonials, right? And testimonials are the advertising equivalent of a personal recommendation. And if we look at the research, what we find is that the vast majority of people seeking a lawyer, their first option will be to go to a trusted source. They'll go to a family member, a friend, a coworker, somebody that they know might have had this experience before, and ask for recommendations of lawyers. People don't shop lawyers that much. They get a name, they go in, they sign up. And so online reviews, I think, are just a step away from those kinds of trusted sources, even though they don't know the people, that they don't have any reason to trust them, but they do get that feedback. And so it would be inappropriate for a lawyer to tell somebody what to say, obviously, to dictate the exactly where they want them to go. But I think that a lawyer, a really good, inexpensive marketing technique is to encourage good clients to give testimonials that can be used either as online reviews or within their other forms of communication. So then let's talk about the clients who aren't so good that might go online and write a review. And that has to do with our issues of confidentiality. An ABA model rule 1.6, which is the dominant rule among the states, although they do vary, says that a lawyer must maintain confidential information about the representation. And there is a stream of thought, and I'm actually one of the people that embrace this, that includes the fact that the lawyer is providing the representation. And so it's a real trap, and actually Illinois has disciplined a lawyer who did this. It's a real trap when you get a bad review to do an online response. And when you do that online response, the chances are overwhelming that you're going to breach your obligation under 1.6, because the out for releasing information about representation is with the client's informed consent. well, this is a client who's hostile to you, and you know they're not going to give informed consent, so probably not even worth asking for that. The remedy would be if the client is rational. The remedy would be to have a private conversation with the client or former client, and say, and to the extent it's necessary, to be apologetic. To the extent it's necessary, further explain the circumstance. Try to let that person vet and get an idea of why they feel the way they do, if you don't already have a clear idea of what that is, with the ultimate goal to encourage them implicitly to review and revise and perhaps take down their negative review. I don't think there's anything inappropriate with having that conversation. On the other hand, marketing experts have told me, I don't know if you guys agree with this or not, but marketing experts tell me that having all golden feedback is not necessarily the best thing, that people do find some attraction to somebody who's gotten dinged. You get 20 reviews and one or two of them are less than five stars or however many you get. And that creates a sense that they're real, that they're authentic, that person, is vulnerable, but generally pretty good. So sometimes it might be best just to let that lay.
Yeah, and I think that is, Amazon did a big study on this, and I don't know that there's been a scientific study in the context of legal reviews, but I think it stands to reason that it does lend itself to authenticity. Now, of course, it depends on the nature of those negative reviews, right? So if it's just like, oh, hey, had a bad experience is different than this person stole money from me. I don't know how many good reviews offset this person stole money from me review. Another thing that we tell lawyers to consider, and this might be closer to getting to the line that you might say, yeah, I probably shouldn't do that. But one of the challenges that people will post either anonymously or under a handle or something, and it's very difficult to identify who the client is. And so we've said, hey, just show some sympathy, respond to the review with something like, really sorry you had this experience. Please feel free to contact us to discuss the situation further. Do you think that is safe enough where you're not revealing client confidences, or you just say don't even try to publish anything online?
No, I think you've carved out a good exception to what I would consider to be the rule. And if you don't know who it is, that's fine. If you do know who it is, I think that could be a problem because, again, you're revealing information that you provided the representation.
Going further into the idea of protecting clients online, at Clio this past year, Aaron Gerstenzang and Kimberly Bennett gave a talk on social media and ethics. And one of the things that Aaron spoke about was when you are posting pictures of your clients online, after winning a case or talking about the outcome, that could potentially be an ethics violation. And I found that very intriguing, and it wasn't something necessarily, just thinking in the broad scope of posting social media pictures, wasn't necessarily something I was thinking of because, you get client buy-in before you post that picture. You say, hey, client, let's take a selfie outside of the courtroom. Are you okay with this? Yeah, absolutely. But that 22-year-old client may actually not be super happy 10 years later about having an Instagram photo with their lawyer online where they got a drug charge remedy.
Yeah. Yeah, Kelly, that's a really good point. The ABA model rule, before it was changed to what it is on confidentiality, required a lawyer to keep confidences and secrets. And then it changed to information about the representation. And information about the representation is broader than confidences and secrets because even if something's no longer a secret, it's still information about the representation. And so, again, the out for that is if the client gives informed consent, then you can communicate that information. Now, informed consent requires the lawyer to explain the adverse consequences, the foreseeable adverse consequences of that. So it's not just, can we take a selfie here and with you congratulating me? And by the way, this will be viewed by people that will know that you had this case. And so, informed consent requires you to go a step beyond just getting consent. So that becomes a challenge to people. Again, I did a Legal Marketing Association presentation shortly after Illinois changed its rule. And I think it was in 2002, but it could be terribly off on that date. But Illinois had the old rule, secrets and confidences. And under that rule, the marketers were putting up case results and all sorts of things without asking the clients. And I explained to them the difference between secrets and confidences and information about the representation. And I could literally feel the air going out of the room. As these people are like, are you kidding? Really? We have to go out and ask them now? We have to go out and tell them that something bad might happen if we do this? And I'm like, yeah, I love marketers, but I have to tell you that you put your firm at risk if you don't do that.
Yeah, I was actually just thinking after you started talking, I was thinking in my head like, oh, what about when people win a $4 million case and then they post that online? And then all of their cousins come out of the woodwork and are saying, "Oh, I see that you won a large amount of money. Can you give me any money?" And then the client's like, "Lawyer, I didn't even think about that."
Yeah,
I'd kind of like to get what I'm trying to seek is some kind of reassurance from someone like Will or other people that are really well versed in this stuff for the new lawyer or a lawyer that maybe has been reluctant to participate online or to participate with technology because of the fear of the ethics. And I really like Will's perspective. Maybe this is as far as we can take it, is this perspective of the opportunity that exists by learning how to navigate the rules and to navigate technology to your advantage, because it can be such a huge competitive advantage, especially in light of some of the changes that are currently going on. That was a very ranty way of, I don't know where I'm even taking that, but that to me, I think is the issue that comes up so often, where lawyers say, look, I don't know anything about websites. What can I put on my website? I don't know anything about I got people saying stuff about me online. I don't even know what I can say back to them. And there's this fear, and I think there's also this reluctance to adopt. And so I don't know, any final thoughts that you can say to encourage folks to really embrace the rules, I think would be useful.
Yeah. Well, first of all, it's a market function. So if it's a good model that enables the lawyer to become successful, that part needs to be demonstrated. The other part is, I don't mean to do this in a self-promotional way explicitly.
You have our endorsement, so
okay,
feel free.
Thank you. Well, but there are people that create and advance delivery models that ask for opinion letters, and they set out FAQs, and they get an expert. Can be anybody with expertise and professional responsibility to address those issues. And frequently the model can be blessed as a whole, and sometimes the specific questions can be answered. And so they provide that information. And I've had in the past clients that have used that information as a tool to assuage those kinds of concerns to reluctant clients, so their own customers. So the ethics issues need to be addressed, but also the viability of the marketing model needs to be something that they're convinced to go for. And if they understand that provides a valuable option to them, and then the vendor can demonstrate to them that they are compliant, that's about as far as that can go. And then, obviously we're going to just recognize that there are a lot of people, a lot of lawyers, a lot of practitioners who aren't going to change, who are perfectly happy with the way things are. There's going to be times where those are not particularly successful practices. And we're seeing a lot of changes. We're seeing fewer people getting divorced. I suspect, I haven't seen any statistics on this, but I suspect we're seeing fewer people pursuing bankruptcy with the economic climate. I think that immigration's a mess. So I don't know what's happening with that, but I'm guessing that there are people who are, we have been successful as a society in driving people who might otherwise qualify for immigration status underground. And the big one is going to be autonomous cars. I mean, the impact of that on the legal profession, I think, is just going to be enormous, and I think it's going to happen sooner than later. We're not going to have any more, I shouldn't say any, but we're going to have nominal personal injury. We're going to have nominal DUI. And those are really major parts of personal legal services that technology is simply going to make if not obsolete, at least far less part of what we do in lawyering than we've done in the past. We need to find that lower quadrant where people
find the opportunity.
Don't know they have a problem and don't know that problem has a legal solution.
I want to spend just a couple of minutes talking about what it is like to have a long career and to be doing what you're doing and then start over and create your own practice and hang your shingle.
Yeah. Well, I so far so good. Let me just put it that way. I'm really happy with what I'm doing right now. And let me say, I was really happy at the ABA, but my functions were kind of bifurcated into managerial responsibilities and substantive responsibilities. And to be very frank, I was never a particularly stellar manager, but I always thought, I mean, my power, and it took me 40 years to discover that I had this power, was to really understand policy and to understand how to advance legal services with substantive concepts. And so I rid myself of the managerial and bureaucratic aspects of it. So what I can do now is focus on the substantive issues. And the ideal client for me is one that comes to me with a problem that has to do with a model to expand access to legal services. And we have a conversation, and I explain to them what the limitations are, what routes they can take, and they come back to me and they say, what if I did this? What if we did it this way? And through that dialogue, through that conversation, we can come up with a model that will both be enriching to them and advance access for people of modest and middle income, if not everyone. And so that's what I enjoy the most of what I'm doing now. I also have a much richer work-life balance because I'm not commuting 3 hours a day. And I appreciate the opportunity to do that. One of my challenges is to have an even flow. So, feast or famine kind of concept. So I'm cautious about how much I market myself and how much I reach out to people to make it known what I do in anticipation that I'll start to assume things that take up more of my time than I want to commit to my work life. And still, not go with an extended period of time without having any recurrent or new client business. So, that's a challenge every solo faces, I think. And I am a true solo. I have no support staff. I have no affiliates, associates, or anything like that. I am a true solo practitioner, and that's the way I plan it to be. I'm not dedicated to growing a practice with this, but I do have some valuable colleagues that work in this area. And when I find something that I'm either too busy to handle or think that they would be better to do, I pass it off to them. So there's a social isolation that's different. And I miss friends and colleagues that I would see regularly and talk to consistently. But I do still talk to people around the country that I've worked with at the ABA as both staff and volunteers. So it's nice to keep in touch, but it's not on a daily basis. And that's a little bit of an adjustment, but I'm very comfortable with that. So thanks for asking.
Yeah, it's very exciting. It sounds like a good problem to be like, well, I'm going to hold off on reaching out to more people because I don't want to have too much work to do. And
right.
It sounds like a great problem to have.
Yeah.
Very exciting. Well, Will, thank you so much for talking with us. I'm sure that everybody now will hopefully have a little more confidence in what they can and can't do or shouldn't do. And it's so great to talk to you about ethics and beyond.
Well, it's really a great opportunity for me to be involved in what you're doing. And you guys consistently put up great podcasts. And I think everybody owes you a debt of gratitude, including the recognition that I think you recently received from the ABA.
We did. Thank you. We really appreciate that. That does mean a lot.
Yeah.
And I would just kind of second what I said earlier. If folks that are listening, if you're struggling with these questions about delivery of legal services, access to justice, and technology, if you have a great idea, I would certainly encourage you to talk to Will. So sorry, Will, if we disrupt your work-life balance, but you're just too great a resource to remain uncontacted. And how would you prefer folks would you prefer folks to contact you? If so, how should they go about doing that?
Yeah, my website is willhornsbylaw.com, and that has my contact information. The best way is to email me, and I'm on the email every day, so happy to get back to people to follow up with that.
Awesome. We'll make sure to include that in the show notes. Thanks again, Will, and thanks for everybody who's tuned in today. And as always, if you have an idea for a show topic, if you're willing to be a guest, if you have a question, or just want to talk about client development, please don't hesitate to reach out to us. We'd love to hear from you. Thanks again, and please don't hesitate to give us your feedback on iTunes or Twitter or other places that you can give us feedback.